If we could all take our seats and get started this morning. All right, so good morning, everyone. I just wanted to begin very quickly before turning it over to Mike for our first panel this morning. I think it's worth mentioning that we definitely have people here today that we didn't have yesterday. So welcome to all of you. Welcome again to everyone watching live streamed online. Especially for those of us who are new today, I just wanted to highlight the conference guidelines that appear in the on the first page of the conference program, and highlight, I think, the organizing committee's just wonderful happiness with how that played out yesterday. I think we said a lot of new and interesting things. We said a lot of direct things, but they were all in the spirit of open hearts, open minds, and fair-minded words. And I look forward to continuing that in today's sessions. I also wanted to mention that today's sessions include concurrent sessions. So as you probably have seen already in the packets, the two sessions after this one, you have a choice to make as to which sessions you attend, and they're obviously in different rooms. Mikosh 10, actually you have to go outside. Mikosh 46, you go out this hallway. But don't worry, there are going to be people to direct you outside to where you want to go, but you just might want to think about that during the breaks. For you caffeine-addicted people out there, I apologize that we didn't have it ready to go at 8:30. It's either on its way or here already. But there is going to be a break after this session where we will have coffee and something to eat. So if you can get through this session, it'll be ready. I think that's all I have to say, so I'll just turn it over to Mike at this point.
Good morning, everyone. My name is Michael Moreland. I teach in the law school at Villanova outside Philadelphia, and I'm also a visiting fellow in the James Madison program here at Princeton for this year. This panel represents something of a turning point in the conference's topics. Yesterday's panels, broadly speaking, took up questions related to the morality of abortion and aspects of that question. And with this morning's panel, we move to the relationship between those topics and public policy and law. And to discuss that, we have four distinguished panelists whom I will introduce very briefly and then turn it over to them, and they will speak in alphabetical order. Beginning on my right, Helen Alvare from George Mason University School of Law, also for many years the spokesperson for the U.S. Conference of Catholic Bishops' pro-life activities. David Garrow from the University of Cambridge, particularly notable in this context for his famous book, Liberty and Sexuality, The Right to Privacy and the Making of Roe versus Wade. Kathleen Kaveny from the University of Notre Dame Law School, where she is the Murphy Foundation Professor and works at the intersection of law and theology. And finally, Dorothy Roberts from Northwestern, where she is the Kirkland and Ellis Professor of Law and the author of, among other notable works, Killing the Black Body, Race, Reproduction, and the Meaning of Liberty. And so with that, our speakers will speak for 10 minutes each. We'll have time for discussion among the panel, and then we'll open it up to the floor. Helen.
Thank you. Thank you, Michael. Can you hear me? Good. Thank you for being here, to gather this many people, to care about an issue and to converse about it. I think maybe you not only possibly share my intuition that abortion is never a single issue, right? It's a kind of fundamental issue. It's always about other things too, but I'm very delighted to see so many willing to discuss it, and thank you for coming. I'm going to take a perspective from the tradition that I've been teaching in, which is family law, which is a little different. A lot of the talk about who is a person and what are persons' rights actually comes from the constitutional law framework. and if you know much about our Constitution, a lot of it is about what the government may and may not do. And the Bill of Rights, where the abortion right has been located, is about what the government may do with respect to individual citizens. And so I think that's one perspective. But it actually, for me, and I think for the millions of women who have experienced abortion and for their families and their friends, isn't the actual context in which abortion takes place. I'm going to propose, within a family law context, which I'll describe, to treat abortion in the context of what I would say are norms that family law uses in the wide array of areas that it touches. Now, those of you, and many of you maybe like my students, think, oh, family law, this is all going to be about divorce and who gets the property, right? But actually, family law is a much wider concern about the relationships between people. It used to be the relationships between blood, marriage, and adoption. Okay, those were it. But then a lot of things happened. You had new reproductive technologies, and you had people who didn't have a blood, marriage, or adoption relationship. You had more and more people who became mutually interdependent, maybe, or didn't, but lived together in cohabitation. You had people who were ex-married, but had a joint interest in children, or maybe some other investment or project. And so actually family law is a lot broader nowadays. I am going to propose an approach to family law, or approach to abortion within family law, that looks at a couple of norms in family law about preserving relationship, caring for the vulnerable, taking care of the whole person, body and soul, and paying attention increasingly to the enormous amount of data that's coming out about the family. And why is this data coming out? Because in the falling apart of whatever you want to call it, the traditional family, we have come to study what happens when they're together, what happens when sex, marriage, and reproduction are separated. And so there's all this data about these different kinds of family forms now that is moving into the legal arena. I could go a little bit through the history of family law, which I love to do with my students, but I don't have time in 10 minutes, to talk about what it used to be versus what it is now. But let me start with what it is now. One of my predecessors at George Mason in family law, June Carbone, you may know her from a book that's getting a lot of attention now, Red States, Blue States. The New York Times did a piece on it, Red State, Blue Sex. Okay, great. Talk about a great headline. And June Carbone's earlier book was called From Partners to Parents. And it is highlighting how it is in family law that through a combination of movements, both culturally and legally, and there's an interplay there, toward out-of-wedlock births, divorce, and assisted reproductive technologies, that through these developments and the, again, cyclical relationship of those with the law in those areas, with the result that sex, marriage, and reproduction have been separated, the law has had to move away from its focus on the parents and getting rights through the parents to the children to a strict parent-child relationship, right? You have 40.6% of all births out of wedlock now. You have 1 million children a year affected by divorce. We have at least 60,000 children a year born by IVF, and then we have other techniques. And so the law has become primarily concerned with maintaining parents' relationships with children. And that, believe me, the law doesn't really care about the parents' romance. It's not weeping that, the adults aren't in love with each other anymore. And it never really cared about their romance in the first place. What it's really after is to keep the children supported from private versus public sources. Let's be frank about that. Anyway, with the new norm in culture and in family law, the overwhelming trajectory of family law, and they're not doing this in for perfectly virtuous reasons or perfectly virtuous means, has been toward the following. First of all, to tie children to private parties who will support them. But they're also has been in the law some enlightenment about the needs of vulnerable children. And they're doing it not just for fiscal reasons, but also because we know that children have Margaret Somerville, the Canadian bioethicist on this, a desire to know their genetic origins, a desire to maintain connection with their families of history. The law has also moved toward, and the data on the family has pushed it in this direction, toward trying to stabilize the parents of these children, particularly people who enter into marriages. It likes to see that if cohabiting people, who are now accounting for all the births that are out of wedlock, 40% of them are occurring in cohabitations. So there's an attempt maybe to get people who are cohabiting to think about stabilizing their relationship. And they're very much focused on empowering parents as much as possible to care for children over the long run in a way that prepares them for this cycle of interdependence, independence that is each of our adult lives. So they're independent enough to stand up on their own as adults without state aid, but also ready for society to be interdependent. Now this turns out to work for adults too, right? Happiness studies, and that actually is a very legit field of inquiry. It has its own journals, etc. In terms of the practical measures of adult outcomes, financial stability, getting a decent education, holding a job. In fact, they've even been able to tie family stability, being raised in a situation where you were nurtured and doing that for your own children, to things like voting participation, lower crime rates, lower rates of divorce, higher rates of education in the next generation. Now, how does this relate to abortion? Finally, okay? If you think of abortion in its component nature, you're talking about a situation where you have, instead of nurturing, destruction of a life by the one to whom the obligation to care is given to at the weakest point in the child's life, and making it a broad constitutional right. And I'd say this is how the mothers who go through it understand it too. I spend a lot of time with women who have had abortions or who are going through crisis pregnancies at crisis pregnancy centers, and they understand abortion as about terminating life and about rejecting motherhood at this time. We look at who resorts to abortion more and who is aborted, and we see again the spillover effects. It's not just how people think about family. African Americans, Hispanic Americans, which is my background, poor, disabled, are aborted more, and their parents the women who are in less advantaged categories in the United States have abortions at higher rates. And to sum up in the final probably 2 minutes left to me this is a rejection of the entire family law trajectory. And I will admit, for those who see motherhood as more as a burden or a cost, they're not going to understand this. I see it as a privileged sort of first experience of what life is actually about, of what family law actually tries to promote, which is the understanding that we are interdependent people, that we are born to care for one another, not to be choosers, but that we are chosen to care. That's what we want in other people, and that ultimately is related to our own happiness. Anyone could read things like Habits of the Heart, Robert Bellah. We owe what we are to the communities that formed us. We need to remember our poverty. We are defenseless on this earth, and we need to join the human race. So the idea that motherhood is a privileged first encounter with what it actually means to be human, and in my view, the heart of what family law is trying to promote in the United States, that I actually think it's even at the heart of our American identity. The idea that we have a generous openness to differences. The idea that we are first and foremost about accepting one another in interdependence, and that the vulnerable have a special place in our heart. 2 final comments, and then I'll stop, which is I think that women know this, that responding to what women say they need in a particular case is not actually what women in the long run show themselves to be made happy by or advantaged by. The law on economics, the psychology on women's happiness, on their long-run outcomes show that sometimes what each of us needs really isn't what we want at a particular moment, that the cycle of independence and interdependence is what is, and we need to be a part of that. Finally, the other things, the two factors that are factors in the presence of family law today that I think our current law and practice on abortion ignores, the importance of the body and attention to empirical data. If we didn't give the body, and here I'm suggesting we extend it to the body of the unborn child, importance, then we would have never moved in the right direction on laws about marital rape, domestic abuse, because we saw that it wasn't politics or culture or biases against women or claims of their overdependence on men that marks what their human rights are, but their body plays a role in that. We cannot abuse them, we cannot rape them, even if they are our wives. And finally, the attention to empirical data. I have to say I'm kind of ashamed of all of us that we haven't moved in the direction, I think maybe it's something we can all agree on, of actually looking at the data on abortion, its effects on women, undoubtedly its effects on the unborn, including the pain studies. When I was at the National Institutes of Health as a council member, it refused year after year after year to put even one question about the most frequently performed surgery in the United States on women into the Women's Health Study. And we should all be ashamed of that, in my view. So from a family law perspective, I urge that regulation of abortion is not paternalistic in any way. It is no more paternalistic than family law generally is about our lives for the well-being of children, but ultimately for the women and other adults as well. Thank you.
Good morning. Okay. I'm a historian of the Black freedom struggle and of the Supreme Court, and I want to begin by invoking a rather formal and rarely used appellate advocacy phrase that my colleagues from legal academia will recognize, and that's that I want to begin by confessing error. And I want to stress that the error is mine and mine alone and is not one that anyone else should be blamed for. Yesterday's 3 sessions, across whatever 5.5 hours or so, led me to conclude that I had erred in agreeing to come and speak at this. Because with 1 or 2 exceptions, the content of yesterday's 3 sessions led me to realize that my scholarly views lie outside the parameters of what was illustrated by most of yesterday's comments. And let me explain, and then I'll move on to 2 substantive elements that lie within our specific ambit this morning. I begin from the scholarly belief that Roe versus Wade and Doe versus Bolton, like Griswold before them, like Planned Parenthood v. Casey after them, were in their core holdings not only rightly decided, but really inevitably decided within the post-1937, post-Caroline products, twin-pillared American constitutional law of due process and equal protection. In addition, for me, American legal history teaches us that Roe versus Wade and Doe versus Bolton are the moral equivalents of Brown versus Board and Loving versus Virginia. I believe, too, that history teaches us, that current American life teaches us, that Roe and Doe, like Brown and Loving, are also the moral equivalent of Goodridge versus Massachusetts and whatever the federal successor to the Massachusetts holding will, in the years ahead, come to be called. So, that's where I come from as a scholarly historian. Now, Helen and I agree quite totally on one thing that she said, and that is that abortion is never a single issue, because I think that is precisely what American reproductive rights history teaches us. Much of yesterday's discussion focused on the fetus and the moral status of the fetus. Now, if abortion were predominantly a question of what one thinks about fetal life, we would not, over the last 35 plus years of American history, have experienced a situation where, I believe it is incontrovertible to say, the vast majority of opponents of abortion are also people who share a deeply principled discomfort, if not explicit opposition, to what I will politely term artificial contraception. Everything that I've learned in 25, 30 plus years about American history has taught me that much, I'm tempted to say it even more strongly, of the discomfort with opposition to abortion has little really to do with the fetus, but is grounded in feelings about sex and about proper sex and improper sex. And I don't think I need to go into great detail for an audience that's probably as knowledgeable as this, but people who believe that sex for some purposes, sex in some contexts, is morally superior to sex for other purposes in other contexts. Now, the status of artificial contraception is one of the reasons why abortion is not a single issue. The second, even more visible reason why abortion is not a single issue is the status of gay people, gay sex, gay couples, gay families. To me, it is as incontrovertible as Brown that gay people, gay sex, gay couples, gay families are in all legal and moral respects the full equals of straight people, heterosexual, vaginal sex, cross-gender couples, cross-gender families. So if the real problem, the real crux of the debate about abortion is about the fetus, we would not also have present these fundamental divides about artificial contraception, about the purposes of sex, about the status of gay love and gay sex and gay families. Now, lastly, we went 5.5, 6 hours yesterday, and unless my UK body clock nodded off at the wrong time, I think we went 5.5 hours without the one word that any federal judge and most law professors would think is sort of the number one word to bring forward in a discussion of abortion. That single word was, I don't believe, ever uttered, though I believe Professor Little spoke about it without using it, and that's the word viability. And to anyone who's a historian of abortion law like me, it's really impossible to talk about the legal status of abortion for more than about 45 seconds without raising viability. And as I said earlier, I believe Roe and Doe were quite rightly decided. Now, those of you who know the detailed legal history will know, too, that it was not in any way a deeply considered decision of the U.S. Supreme Court in the late fall of 1972 to structure the trimester framework as the final decisions did. It could very well have come to pass that Roe and Doe would have drawn a bright gray line at the end of the first trimester and left it at that. The justices who put forward the trimester framework did not at all consider, because they didn't think it mattered, what the difference was between the 3-trimester to end of first trimester viability, 2 constitutionally significant lines, and the alternative choice of simply authorizing legal access to abortion up through the end of the first trimester. Now, The discussion that I would like to have in a setting like this is how negotiable should the legal status of the second trimester be? I am far distant from Professor Singer, I think it's fair to say, because I view live birth as about as bright a line as you can get. But, to the disappointment of many people here, I also view fetal viability at 22, 23 to be the next brightest line we could ever get. However, I quite frankly am not morally capable of having a discussion that doubts women's fundamental right of access up through at least 12 weeks. Now, having said all that, I'm perfectly willing to discuss everything about 12 through 22. Now, that worries me in the sense that it could be a sort of Kansas-Nebraska slippery slope, or that it would be the equivalent. No, let me not use that parallel. That might be viewed as an unfriendly parallel by some people. But while I believe that 12 weeks and 22 weeks are fundamental lines, I do think that it is imaginable as a pro-choice person, and there may be some of my colleagues here, Dorothy, Robin, Dawn, who would disagree with me on this. I do think it is possible to entertain the question of whether 12 forward should be subject to the sort of hospital committee regime that we saw in abortion law history in the late 1960s. Now, I concede that, acknowledging that it will put poor women, teenagers in denial, disadvantaged women of a variety of sorts in humiliating positions. And that's why I am uncomfortable with it and compare it to Kansas, Nebraska, if everyone understands my historical invocation. So that is a moral concession I'm willing to entertain as a possibility, even though I view it as a potentially dangerous slippery slope. But that's where I come out as a historian who believes, and will always believe, that Roe is the moral equivalent of Brown. Thank you.
Oh, my thingy. Excuse me. Good morning. I feel a little, as an academic, a little kind of vulnerable and almost naked up here, because what I have to give you is a set of assertions and not any arguments for those assertions, because we've only got 10 minutes. So I just want to start by saying I know what I'm giving you is a set of assertions, and I hope that during the rest of this conversation, during the rest of this conference, we can talk more about what's entailed in them. But I thought the best thing to do would be give you some sense of how I approach the question of the morality and law of abortion kind of straight through, just giving you an outline of what I think. And I recognize that all of these points are capable of being challenged, but I'm just going to tell you what I think about this. It seems to me that a person's view of the appropriate law of abortion, and here I'm prescinding from the constitutional questions which will be discussed fully later today, depends on three factors. First, one's view of the underlying moral issue, not only including one's view of the right analysis of the act of abortion, but including one's assessment of how clear and certain that analysis is. Second, one's view of the purpose and limits of positive law, not only in general, but in a pluralistic society such as our own. And third, one's view of how human beings act, what sort of incentives, both positive and negative, that they respond to. And I'll try to say a few words about each. So let's start with the moral issue. First question, of course, was the status of the fetus, and that has to, it seems to me, enter into an analysis of the law. I believe from very early on in the pregnancy, by the time that twinning is no longer possible, that the unborn is a human being and equal to all other human beings in status. I do not distinguish between human beings and persons. The unborn does not have less dignity because it is small, vulnerable, or dependent. On the other hand, it does not have more dignity because it is small, young, and cute. Justin Bieber is not the most valuable human being in the planet. Even with the equal status of the fetus, I still think abortion is a hard question for two reasons. First, the act of abortion is rightly describable, sometimes in one way, sometimes in another, either as intentionally killing the unborn or as intentionally separating the unborn from the woman who carries it. The second description is not trivial. Pregnancy does not require mere neutrality of the woman toward the unborn. It requires a great investment of the woman's physical strength and often emotional connection as well. I think Maggie Little pointed out that very well yesterday. The unborn does not merely exist in the woman, it draws sustenance from her, at times at great cost. A third factor in the moral assessment of this is, I think, the status of the woman. And this has to be on the table as well. Women are equally protectable human beings. The nature, destiny, and the purpose of a woman is not merely to provide gestational support to unborn life. It can include that under certain circumstances, but it is not merely that. Now, Western culture, law, and morality have, it seems to me, been marred by a certain type of sexism. So whatever moral and legal rules regarding intentional killing and the duty to provide bodily life support are applied to the case of pregnancy need to be scrutinized as well for consistency with the moral and legal rules about these topics in analogous situations that do not involve pregnancy. We need to look to make sure there's a certain type of consistency. My bottom moral line is this. I do not think a woman ever has a right to ensure that the unborn dies, intentionally killing the innocent. Under some circumstances, I believe she has a moral right to end the draw upon her body created by the pregnancy. Under most circumstances, I think a healthy woman who is pregnant as a result of voluntary sexual intercourse has a moral obligation to carry the baby to term. But I do not believe she has an obligation to provide life support to the unborn if pregnancy implies a significant burden on her health or if she was raped. That's under those circumstances, I think those actions are describable as intentionally ending the burden of the pregnancy and can be described differently than intentional killing. Doing so, of course, is an act of supererogation and is praiseworthy, but I don't think can be morally required. So that's my background moral view in a nutshell. How do I take that and move to law? Well, in order to assess that, I need to say something about the nature and the purpose of positive law. What is good law? I think the definition of Isidore of Seville, a 6th and 7th century kind of canonist and bishop who did one of the first summaries of kind of knowledge at that point, actually makes a lot of sense today. He says, good law shall be virtuous, just, possible to nature, according to the custom of the country, suitable to place and time, necessary, useful, clearly expressed lest by its obscurity it lead to misunderstanding, framed for no private benefit but for the common good. Now, I can't talk about all of these in detail, although I think it would be good to look at the panoply of abortion law in light of these criteria, but I want to focus on two items on the list: virtue and justice. One of the functions of the law, it seems to me, is to teach, to inculcate and promote ways of acting that the society believes are good and virtuous. Is that possible in a pluralistic society such as our own? It would take a long argument to show that, but if you think about the Americans with Disabilities Act and the Civil Rights Act and the Family and Medical Leave Act, I think it is possible. At the same time, the level of teaching that the law has to engage in has to be very basic. It has to be designed for persons of ordinary virtue, not for saints. And the law as a whole has to teach not merely with the tools of the criminal law, which I think have very, very limited application in the case of abortion, but with other sorts of law. What is important to me is that the totality of abortion regulations, that is all criminal, public health, and social welfare laws relating to abortion, be in proportion to the importance of the legal value of life, and that as a whole they work for the continuation of the pregnancy. So that's what I'm going to say about the teaching. About justice, I just want to add one thing. When we look at the justice of a law, you can't just look at kind of the injustice of the act of abortion. You have to look at the distribution of burdens throughout the society. Lots of people quote St. Thomas Aquinas in the pro-life movement and say an unjust law is no law at all, it's just merely an act of violence. St. Thomas Aquinas also said that a law which distributes burdens unequally, although with a view to the common good, is also not a law, but is also an act of violence. So one of the key factors, it seems to me, in looking at a just legal system is trying to ensure that the burden of caring for the vulnerable does not merely lie upon the women who get pregnant. The third factor, and all of these can be expanded, and I'd be happy to, is in thinking about law, you have to think about effectiveness. What works? What doesn't work? It strikes me that we have to see whether prohibiting, especially with criminal prohibitions of abortion all across the board, is actually effective in reducing the rate of abortion. And so I'm very concerned with the study in 2007 that indicated that societies which criminalized abortion did not succeed in reducing the rate of abortion. And I think that has to be taken into account in wise jurisprudence. Is there a place for common ground on abortion? One area where I'd like to see some effort is in the realm of kind of informed consent provisions. There's lots of people that want to provide abortion, information and services. What kind of information should be provided to women who are seeking abortion? What would it mean to be fair? So that's my magical mystery tour through the morality and the law of abortion. It's a set of assertions, but I hope it provides a basis for a common discussion. Thank you.
Good morning. Like David, I came home. Hotels are now my home. But came back to the hotel last night and also thought that a lot of the discussion yesterday was outside the scope of issues that I usually think about and work on when I work on reproductive justice. But I didn't think that I shouldn't have come. I thought I'm glad I came so I could talk about it and add that to the discussion that we had yesterday. And I actually, looking back at our charge to talk about law and policy, given the disagreement about the morality of abortion, I found that to be very liberating because it seemed yesterday that the question of the morality of abortion was taken to revolve almost exclusively around the moral status of the fetus and women's moral duty to the fetus. And so now I felt we could discuss public policy that recognizes that pregnant women have a moral status as self-determining human beings. And we should recognize that. Kathy mentioned that in her comments, and I would add to that, public policy should recognize that our society has historically and still values pregnant women according to unjust and illegitimate hierarchies of gender, race, class, ability, and sexual orientation. So I just want to make 2 points then to move forward from the talks and discussion yesterday. One, that women matter, and not only in relation to a fetus, and also that all women matter equally. I joined the struggle for reproductive justice in the late 1980s when I heard about a case involving a woman named Angie Carter, who in her last trimester of pregnancy, while she was dying of lung cancer, was forcibly operated on. Doctors at George Washington Medical Center felt that the fetus wouldn't survive if they didn't perform a cesarean section, and without her consent, they performed the cesarean section with the order of a judge countenancing this, and killed her, and the fetus wasn't viable and died as well. And when I heard about that, at the time I was practicing law in a big law firm in Manhattan, and I was just totally shocked by that decision. I had 2 main thoughts. One was that it occurred to me that women could be completely devalued to such an extent that they could be cut into without their consent just because they were pregnant. And it also occurred to me that if the government devalued a white woman in this way, imagine how the government would devalue a black pregnant woman. I've since come to think of Angie Carter not just as a white woman, but also as a woman with a disability, and link very much what happened to her to what happens to poor women of color around this country because they're pregnant and because their motherhood is so devalued. I soon discovered that there were prosecutions going on at that same time, just beginning, but they expanded around the country, of women who had substance abuse problems, and discovered that the vast majority of these women were poor black women, although substance abuse during pregnancy cuts across race and class lines. At the time, most of the prosecutions were targeted at poor black women, and they were treated in the most inhumane fashion, literally dragged from maternity wards, still bleeding from delivery, kept in prison while they were pregnant, and then chained and shackled to the bed while they gave birth. Just extremely inhumane, I'd say, forms of torture of women. Again, because they were pregnant and because their motherhood and reproductive decisions were utterly devalued and disrespected. And there's a broad range of laws and policies that involve state intervention or allow for state intervention in the lives of pregnant women, compelled surgeries, prosecutions, but also coerced sterilizations and birth control, welfare policies that deny an added increase in benefit to women who have a baby for the explicit purpose of deterring them from having children, and as well as denying access to abortion. I put all of these policies together. I see them all as policies that devalue women's reproductive decision making and do not treat women as full human beings. And all of these actions and policies and laws occur according to the social status of the mother. Speaking specifically about black women, although as I mentioned, this happens to women because of their immigration status, their sexual orientation, and their poverty, and also their race and ethnicity. But there are deeply embedded stereotypes about black female sexual and reproductive irresponsibility that support welfare reform and law enforcement policies that severely regulate poor black women's sexual and childbearing decisions, even today. Judges and legislators view poor black women as suitable subjects for harsh reproductive penalties because people in power don't view them as suitable mothers in the first place. And by identifying their procreation as the cause of deplorable social conditions, these kinds of reproductive punishments and regulations divert attention away from the need for social change. Policies that encourage abortion and other restrictions on childbearing as a solution to social problems are just as guilty as policies that restrict abortion, that have this false and reprehensible thinking behind them that blames reproduction for problems that are actually caused by social inequality and oppression. The most effective way of maintaining an unjust social order is to get people to think it's written in nature, and then punish people for having women, for having children, on grounds that they're the ones causing all these social problems. So I think we also have to be careful when we think of what our common values are to make sure that they're rooted in social justice. Because even what we think are common grounds that are an unadulterated positive good and seem uncontroversial can also be racist and sexist if we don't watch out for that. So for example, yesterday adoption was talked about as totally uncontroversial. It's a total positive good. What could be wrong with it? But we have to recognize that the adoption system in America is profoundly racist, profoundly based on economic injustice. It places a premium on, literal monetary premium, on white babies, and caters to the interests of the white middle class and affluent people, while devaluing children of color, again literally in monetary terms, especially black children, and devaluing their family bonds. So most of the children in the U.S. foster care system who are available for adoption are children of color, and they're available for adoption because their parents' rights have been terminated, usually against the parents' will. Now, women of color have been, for a long time, promoting a distinctive and engaging in a distinctive activism that sees reproductive freedom as a matter of social justice. It recognizes that procreation's special status, why we pay so much attention to rules about reproduction, stems as much from its role in social structure and political relations as from its meaning to individuals. It places reproductive rights in a social context that makes government provision of family planning contingent on improvements in general health and living conditions, and that the legal fight for reproductive freedom must be part of a broader struggle to create a more just and egalitarian society. I just want to make one final point about what does this mean about rules about abortion. Yesterday it was said abortions occurred before and after Roe. They're going to continue occurring even if they're criminalized. Kathy just mentioned a study that showed that. The difference is that more women died from illegal back alley abortions when it was criminalized, and more women will die if Roe is overturned. Most women who will die from illegal abortions are poor women of color who can't afford to travel to states where it's legal or pay enough for a doctor who's willing to perform it in states where it's illegal. Another major difference is that before Roe, in many states, therapeutic abortions were permitted, and so doctors could make the decision on eugenic grounds to permit an abortion. I think it's better to let pregnant women make the decision for themselves. So given the disagreement about the morality of abortion, we have to let women make the moral decision for themselves, but we should go way beyond Roe. I don't think Roe is enough to promote laws and policies that dismantle the oppressive systems in our society that devalue women and children on the basis of gender, race, class, and disability. Thank you.
Well, we have a few minutes now for some exchange among the panelists, and then we'll open up to questions from the floor. I know I have some questions, but I'm wondering if any of you have questions for one another.
I have a question for Dorothy. Because I completely agree with you that so many of the systems, economic, political, legal, are racist in nature for a long time. And remain so. I'm looking at some of the current economic policies with reference to African American unemployment, housing. It's unbelievable there's not a revolution going on about it. But with that, it seems to me that you might wish to admit the possibility that current abortion policy is also racist. And by that, I'm looking at the numbers of people who support abortion precisely because, and this was a quote out of context, but it had its meaning of Ruth Bader Ginsburg's interview with the New York Times. I thought it was related to having fewer people of the kind we didn't want, she said. I thought that's what Roe was about. Then you have African Americans disapproving of abortion more. If you read the qualitative literature, that beautiful book, Promises I Can Keep, Why Poor Women Put Motherhood Before Marriage, they say it's not decent, it's not noble for me to do that. There's a narrative of success in my life, and it includes being basically a heroic mother. That you have this outrageous, African Americans are 13, 14% of the population, they're having 36 to 40% of the abortions, etc. It seems to me that the devaluing of African American life that has and is going on, and again, I cannot express how disgusted I am at the lack of conversation about it now in the family and the economic context, that the abortion system we have now, that is Roe, Casey, is an expression of it, not a gift to the African American community to neutralize it.
Well, I agree with you that a justification for abortion that says abortion should be legal to eliminate people who don't matter or who are causing social problems. That was a central theme of my talk. I agree that
but
that
even if
is
de facto it results in that. Not if, even if you don't have private intentions, but if that's what happens.
Well, I make it, there's a difference between making abortion available to women to decide whether they want to have one or not, and having policies that encourage it because you devalue those women and their children. I think there's a difference between the two. There's a difference between having access to family planning so that women can make the best decisions for themselves, and having policies that coerce women to use family planning or that mandate them to. So, I mean, there's a difference between mandating sterilization, coercing sterilization, and providing it as an option.
And I'm saying that there can be racism in subtle markers, not just overt intentions of law. If you have people who presently are not getting a fair share of educational or economic pie, and you have a wide open abortion policy, it is a free play for discrimination to happen de facto.
Okay, let me address that. The solution to that is exactly the way that women of color activists who are engaged in a struggle for reproductive justice would look at it, which is you have to simultaneously make family planning available to women, but also address the unequal economic and social conditions that exist in this country. They're both important. You have to do both. You don't deny women access to family planning that they believe they need and want in order to address this concern that you have about the social issues. You have to struggle for both. And I just want to say
one comment on that, and then we'll stop that.
let's
I
get
totally
Kathy and
agree on
David
the
as well.
social and economic issues.
Yes.
I would just say you also have to value lives, value connection, in the same way that actually you find the African American community and all the beautiful studies of it indicates they do. So I would welcome a dual policy, but one of mine would be the opposite of yours.
okay.
Kathy or David?
I guess two kind of comments. One, I do recognize that many people, especially within the Catholic community, who oppose abortion also oppose contraception. But I think it's at least possible, for a group of people not to be morally opposed to contraception as the, preventing and the coming to being of a new life. And also kind of morally worried about abortion as either the intentional taking of a human life or the refusal to provide support to a life. So I suppose what I'd like to know a little bit more from you is what makes you unable to see or makes you not want to see or not think it's legitimate to see the attempt on the part of people to kind of at least disaggregate these two things? Why do you insist they be put together? What's causing you to do that? Just the fact that people who hold one position often hold the other, or is there a logic that you see in that?
No, I certainly don't see a logic in it, but I think that what we've seen going back before Griswold has linked the two oppositions so intimately in terms of the fundamental rationale. The focus on the fetus as the crux of the abortion issue is to a significant degree greatly increased beginning in 1970 after the New York law takes effect. So I want to be sure I say this as respectfully as possible and people not take it as some sort of put down, but let me try stumbling forward. Perhaps in no way consciously, adopting a focus on the value of the fetus is a more politically attractive emphasis for advancing a position which, at whatever level of consciousness, is more fundamentally rooted in a profound discomfort with all sex acts that are not intended to be, or not open to, if I'm saying this more respectfully for the tradition, are not open to the possibility of procreation. Now, I'd like to go, if I can make this parallel successfully in terms of what I just attempted to say, let me also very quickly say something in terms of what Helen and Dorothy were discussing, because it's been my perception the last 2 or 3 years within the legal academy that it is an increasingly attractive stance for anti-abortion people in the legal community to emphasize the racially discriminatory impact of abortion. And I've read several papers by pro-life legal acquaintances where the degree of their investment in the discriminatory impact of abortion, I'm afraid, strikes me as a political strategy or political stance.
it is an explicitly political strategy. It's not just academics. There's a whole campaign going on, starting in Atlanta, Georgia, and moving throughout the country of billboards that say that abortion is a form of genocide in the black community and make statements like a black woman's womb is the most dangerous place for a child. You know, to me, a statement like that sounds exactly like what people say when they want to punish black women for having children, that their wombs are creating all these social problems, therefore we have to punish them and restrict them. And I'll just mention there's a counter-campaign that women of color are involved in now called Trust Black Women, which is black women have the ability and right to decide for themselves whether or not they want to use abortion and other forms of family planning, and have advocated for access to family planning for at least a century in this country.
So quick comments by Kathy and Helen, then we'll open it up.
There was one of the most interesting kind of public intellectuals writing today is a woman named Eve Tushnet, who's Mark Tushnet's daughter, who is a lesbian convert to Catholicism who's pro-life, believe it or not. All of those things are together. And one of the things, wrote an article very recently talking about kind of this new convergence in political views, not culture wars, almost beyond the culture wars, where she's talking about how many people in the younger generation are in fact pro-gay marriage, so therefore not as, worried about hinky sexual acts as you seem to think that, people are, but also more pro-life, not necessarily legally pro-life in the sense of restricting it, but more in the sense of trying to provide the culture to create the possibility for women to choose to bring their babies to term, and also willing to say that generally speaking it's better if we can figure out a context to bring this to a life rather than to the end of a life.
Very brief, just to try to reach out here. I don't know. I don't off the top of my head know what Ted Olson's position on abortion is. But I will say that whatever his position on abortion is, I view Ted Olson as a heroic figure. If people understand my context.
I just want to correct a few factual things, because at a certain point, statements about what's a political strategy and what's genuine, or statements about relationship between contraception and people who are pro-life need to actually attend to some facts too. And the facts of, if you spend any time, as I have for I don't know how many decades now, with the women coming into crisis pregnancy centers or post-aborted women, you'll see that the concern about the disproportionate, not only abortion rate, but after effects of abortion on these populations, and in the Catholic Church even, from which I come, the number of Hispanic women is one of our largest, and it's going to be majority. We are genuinely concerned that this is a new form of discrimination. It's not a political strategy. It's a function of having helped millions of women and seeing the situation. Second, with regard to contraception, oh my goodness, I've been hit over the head with this so many years. If you actually look, they try to get the Catholic Church on this in the press often by saying, they don't even believe it. 3 to 4% of people believe it. So people don't believe it, and if we don't believe it, I'm guessing not many non-Catholics would adhere to the Church's teaching on it. We don't believe it, but it's driving all of our movement on the abortion issue. Like, you can't have it both ways. Either we buy the Church's teaching on contraception and we tie it, or we don't buy it, which it seems that the studies show most Catholics do not. Most of them aren't terribly familiar with it, but they do not. But somehow that's driving our movement. At a certain point, you really do have to attend to some facts about what's the case, underlying some conclusions about where the pro-life movement is going.
Well, let's open it up. A few notes. One, I'd ask that people who have not had an opportunity to ask a question yet be given the first break here. And I'd ask you to identify yourself, your name and your affiliation, and then if you could please recover the lost art of making a brief comment or question, and be very to the point. But again, people who haven't had a chance yet, I'd ask be given the first cut at it. Paul Sigmund.
Paul Sigmund in the politics department here at Princeton. I have questions for Professor Kaveny and Professor Garrow. In the case of Professor Garrow, you kept talking about rho doe, and Brown equals rho doe. And as I understand it, and I'm not a lawyer, one of the reasons, for instance, that Professor Finnis yesterday mentioned rho and doe was to emphasize the difference between the two of them, at least in their application. That the Doe decision essentially makes an exception to the trimester system for the health of the mother, and then defines the health of the mother so broadly that it appears to be a slippery slope, and some argue that it has led to abortion on demand. But then later you talk about the trimester, something about the trimester. You have a kind of trimester view yourself, and seem to favor that. And so I guess my question is, how do you reconcile the kind of equation of Roe and Doe with the kind of favoritism towards some kind of application of the trimester system? For Professor Kaveny,
very briefly, Paul. Briefly to Kathy. Yeah, go ahead.
Oh, briefly. Okay.
They cut him off.
A very interesting case study here, because all Latin American countries prohibit abortion. There are figures.
No, there are parts of Mexico where abortion is permitted for everyone in the first trimester.
Let's move on.
The basic question is there is despite the fact that there's a widespread prohibition of abortion, about 40% in some countries of pregnancies end in abortion, and a significant portion of them end in the hospital. Question: what about the application of St. Isidore's provision of workable? How would you advise someone who gets involved in the debates that are beginning in Latin America on the question of abortion?
Thank you. Over here.
Thank you. I'm Marianne Moleman, Advocacy Director for Women's Rights at Human Rights Watch here in New York. I am also Danish, and so I grew up in a country with public policies that facilitate voluntary motherhood in a way that I have not seen in the U.S. And I would like for all of the panelists to speak to what kind of public policies, not on abortion, on other issues, which I was struck with the phrase incentives that humans respond to. What incentives would human respond to in terms of having a real choice? And I'm thinking about issues like parental leave, child care, health care, etc. So if you could speak to that, thank you.
Thank you. We'll take two more, and then we'll have some responses.
Hi, my name's Lucinda Finley. I'll direct my question to Professor Alvare, although it's one anyone is welcome to comment on. First, I found your asking us to think about abortion in the context of the norms and policies of family law very interesting and helpful. I think we could take the same norms you articulated and use them to explain a woman's decision, in fact, to have an abortion. But my question is, I wanted you to pick up the point that Professor Kaveny mentioned, the sort of pragmatic point that in countries where abortion is illegal, one of the leading causes of maternal death is from illegal abortion, which often then leaves the rest of the remaining family without that nurturing parent. So how did your norms of family law encompass the reality of the effects of illegal abortion?
Peter Colosi from St. Charles Borromeo Seminary, teaching moral theology and philosophy there. And my question is for Professor Garrow. The force and clarity with which you defended Roe at the beginning of your talk, and then the force and clarity with which you drew your 3 bright lines, live birth, 22 weeks, and 12 weeks at the end, struck me as contradictory. And the ones at the end, you didn't really give a reason for the bright lines. You mentioned the word viability, but that shifts around a lot. And when you said 12 and 22, it reminded me, I think it was about 10 years ago, Tony Blair saw a fetus walking in the womb. We had that brought up yesterday about these beautiful images of twins and babies in the womb. And he went into the House of Commons and he said, I want to change the social abortion law back because I saw this. So anyways, your bright lines seem to be quite focused on the fetus, and could you say why?
All right.
Or is that? Okay.
We'll answer and then go back.
Okay. Paul Sigmund first, then. I think it is indisputable that Roe and Doe were intended to be read inseparably and should be read inseparably. In the actual composition of the opinions over the course of 1972, pieces moved back and forth. Initially, the plan was that Doe would be the lead opinion, not Roe. And so if anyone thinks that they should be read apart from each other, that, as a historical matter, is simply wrong. Now, I continue to fundamentally believe in and this speaks to the last gentleman too, though I'm wholly unfamiliar with anything Tony Blair has ever said on abortion. I continue to believe in the fundamental constitutional analysis of the trimester structure, that there are 2 separately identifiable compelling interests, one of which is the protection of viable fetal life, which, as I understand the huge literature, has not measurably changed over time. And that there is a separate compelling interest in protecting the health of the woman, which was the template for 12 weeks. And as some of you here know, I wish the pro-choice movement historically, in its stance towards clinicians, would have been more protective of women's health. So I see no tension at all between my endorsement of Roe and Doe and my fundamental acceptance of the trimester framework, with the concession that I attempted to articulate, that I'm open to a conversation about how we view the second trimester, though I view that conversation with great leeriness. Lastly, and I'll say no more, on the question that the young lady asked about non-abortion matters, and I thought of this listening to Helen and Dorothy, in terms of the impact of public policy, public health matters in a racially discriminatory way, God, do I believe in gun control and what the availability of guns does to young people in Black America. Vinny.
Well, I can follow up on that. In terms of policies that would promote voluntary motherhood, which I hope is one of the main common grounds we could agree on. First, there would have to be policy, an end to policies that are punishing the women of color. I'll focus right now on women of color for having children. So child exclusion policies under welfare law, mass incarceration. We have the highest incarceration rate of any country in the world and unprecedented in the history of Western democracies. The high incarceration of Black men and women imposes all sorts of restrictions, reproductive restrictions on men and women. An end to prosecution of pregnant women for so-called fetal abuse, and massive change in our child protection system, which currently punishes families because they do not have the resources to take care of their children by taking their children away from them. And then there would have to be a whole set of positive state supports like universal health care, family leave policies, child care, universal child care, income supports, support of education, college education for women, job creation, living wage laws, and a whole set of laws and policies that truly support caregiving. And just to relate that to Helen, your point about norms in family law, a lot of the norms in family law now are moving toward privatization of the care of children and other people who need care, and away from public support. So even though there's some good changes in family law, I would want to reverse that trend to recognize the need for strong public support for caregiving in this country.
I'd like to echo what you said on that. I think that really is a point of common ground. And for me, thinking about it, from a pro-life perspective that sees the unborn as equal in dignity, I do think there's a separate question about the justice of how we distribute the burdens of caregiving for the vulnerable in our society. And so I think many of the policies that you're talking about, I'm very committed to. Professor Sigmund, it's nice to see you again. I graduated from Princeton. He was one of my professors. And I think you're entirely right. I think that good law has to take into account what can be done in a particular society. We've got, and while law has to point beyond toward, kind of a virtuous community, what it would look like if the lion lay down with the lamb, what it would look like if people behaved better, it has to take into account where we are right now. And pushing any values or pushing any norms that are too far beyond what the society can bear at a particular time. It's like exercise. You do not stay on the couch for 10 weeks and then get up and run a marathon. We've got evidence in society. Look at the first Civil Rights Act in 1875. It was passed. It was declared unconstitutional. Jim Crow came in after that. That needs to be studied if we're seriously thinking about how to do this. Prohibition needs to be studied. What happens when you go beyond what a society can bear at a particular point in time in making law? Those are the questions I'm interested in at this point.
Helen, briefly.
Okay, just to second the great point from the first question regarding policies for being able to welcome children. That, I think, we all understand is a great social good. In the United States, we exclude mothers from Social Security. It's insane. Obviously, both public and private flex work policies, health care for everyone, etc. But I'd like to add something, because I think we can widely agree on some of those, which is one of the best ways to support a motherhood that, and I'm referring to Brad Wilcox's studies and many others, actually to support marriage in connection with childbearing. And that makes me say, oh, now she's going into controversial territory. But it turns out, statistically, over a very long period of time, you can look at evolutionary biology, neurobiology, psychology, sociology, to support a woman in her childbearing and to have the man's support remain invested in the child is through marriage. It's a very, very tenuous social experiment to try and connect men to their children without it. It doesn't tend to work. Second, with regard to, I'll just mention points that have to be looked to. I can't see where the woman is who asked about the deaths when abortion is illegal. Several things you need to consider when analyzing that. Number one, what do we know about deaths before, for instance, let's look at the U.S. context. Roe. We know the man who cited the most widely reported figure then reported that he did make it up out of thin air, one of the co-inventors of NARAL, Bernard Nathanson. Number two, we know that there's no mandatory reporting today in every state of deaths from legal abortions. So that's a question out there. We have very spotty, we get these abortionists, 5 or 6 in the news now with horrific conditions in their clinics, and we say, wow, that's not reported in any state statistics. And the final point on that, and I happen to have them with me if you'd like, we have these marvelous studies from the law and econ folks, sociologists, etc., about the long-run relationship between legal abortion and the well-being of women. Abortion changes the sex market, the mating market, the marriage market in ways that I won't go through here, but Levine at Wellesley, Akerlof, Yellen at Katz, Chicago, Click at University of Pennsylvania. I have them with me. We don't think that the long-run good is associated with a wide-open regime of abortion. In fact, this declining paradox of the paradox of women's declining happiness, Stevenson and Wolfert. There's a speculation, and it's not unfounded, that the relationship between wide-open abortion and the change in the sex, mating, and marriage markets that's made possible is associated with declining well-being for women. So, all of those factors.
There are 7 people in line. Let's try to collect all 7 questions, be very brief, and then we will have time for the panelists to respond to those that they choose to respond to. Sharif.
Sharif Garius, Princeton. Question for Professor Garrow that was posed, but unfortunately I don't think answered, or if it was, I missed it. In asserting that the pro-life movement is much more about controlling sexual behavior than it is about defending life, you've implicitly imputed bad faith to millions of Americans, or maybe half this room. And so I'm wondering what the evidence for that conjecture is.
Right, let's just finish that line there, and then we'll move over here.
Rachel Collins, Oxford. This is for Professor Roberts. I have 2 questions about your data statistics. So the first is, I think it was you who made this comment, that abortions don't decrease if they've been made illegal. But the research also shows that abortions do increase if it's made legal. Secondly, are you not perhaps overstating the racism endemic in adoption? The 2007 survey by the U.S. Department of Health and Human Services of all adopted children in the U.S. found that 37% of all the adopted children in the U.S. are from foster care, compared to 38% domestic adoption, 25% international. And in fact, 40% of all adopted children are of a different race to both parents. And as an impersonal side, as someone
Please, let's just go on to the next question if we could.
Okay.
All right, thank you.
Hi, my name is Christina Page, and considering Professor Garrow's comments about whether the gestational age and whether we can decrease the gestational age of abortions, I wanted to ask the pro-life panelists if they would consider the fact that pro-choice policies tend to lead to earlier abortions. We see the studies show restrictions on abortions push women later into pregnancy. So what if we were to find that, in fact, it were pro-choice policies that would reduce the gestational age? And do you think reducing the gestational age of abortion is a common ground goal?
Just, if I may, on finding common ground, my name is Lynn Paltrow. I think we have common ground on marriage. My partner of 22 years and I have children who would like us to be able to get married, but we're not allowed to. One of them is a freshman here at Princeton. My question is this. My experience is in working with how the argument that the unborn have separate moral and legal status is used to affect women who are giving birth. My experience with family law is the trajectory is punitive and disruptive because child welfare cases are there. So the question is, when a woman like VM in New Jersey refused to pre-authorize cesarean surgery, and she was reported to child welfare for medical neglect of her unborn child. We are seeing cases like this all over the country. I was wondering if you could discuss what the implications are for the use of family law in that way.
I'm Kelly Brunacini from Feminists Choosing Life of New York. I'm very interested in the notion of laws as teaching tools, and with many young girls that I know in mind who view, I'm almost done, who view pregnancy as a blockade to achieving their dreams. I'm interested in what the panel's view is on what Roe v. Wade is teaching us about the value and potential of motherhood. I'm Jessica Gonzalez with the National Latina Institute for Reproductive Health. Dr. Roberts, thank you for uttering the words reproductive justice. We haven't heard this whole time. But for those that support fetal personhood and fetal rights, the same policymakers in the U.S. who support fetal personhood are the same policymakers that demonize immigrants and the choices of immigrant and their families. And I wonder if you could talk about reconciling the work of the fetal rights with those that seek to revoke the status of immigrant women and their families, such as revoking the 14th Amendment birthright citizenship.
Very briefly.
Yes. I'm wanting to ask about the cases in Roe and Doe because the plaintiffs in this case were unnamed, but we do know their names, and I think we honor the women by naming them. Mary Doe was Sandra Cano.
Do you have a question?
Yes. And Jane Roe was Norma McCorvey. And the question is, given that both of them now, Sandra Cano never was.
Please, could you ask a question?
Okay. The question is, since they're both very strongly pro-life now, and Sandra Cano always was, is there some exploitation involved in the legal things that might also have been inevitable that should be taken into account?
We're right up against our deadline, so I'm going to go right down the row here, 45 seconds each.
Okay, that's it. I've never seen evidence with regard to the relationship between allowing abortion legally and leading to earlier abortion, so I'd have to really see that. Obviously, the position would be that we would like to save women's health when we can, and later abortions are more risky, but I really don't know that there's a relationship between the two, and denying the fundamental principle of the not killing is still problematic. And finally, with regard to the political question about the coincidence of anti-immigrant and pro-life sentiments, politics stinks. I hate partisanship. It's why I talks on both parties, okay? And that's why people like probably a lot of us here who have what we hope to be a good social justice conscience, whatever the divisive issue, racism, sexism, anti-immigrant sentiment, could also agree that maybe we should look twice at least at the pro-life issue as a piece of that problem, not a solution, abortion.
David.
I'm a far-lefty liberal, and I'm nauseated by the Democratic political ads I see on TV. 3 quick answers. I look forward to when the National Right to Life Committee endorses universal access to contraception. Neither Sandra Cano nor Norma McCorvey were in any way misrepresented by their attorneys from 1970 to 1973. And 3, I very much would like to point us towards pursuing and discussing Christina Page's very, very valuable comment about gradations in gestational age, because if this doesn't further confuse the gentleman who addressed me earlier, I'm happy to acknowledge that even I see a measurable difference between, say, 8 weeks and 16 weeks. I think the gradations matter big time.
2 points. First, on reducing the gestational age at which most abortions take place, I'd like to see the studies, but I think that this is a good idea. The wrongness of any kind of homicide does not only depend upon the dignity of the human being who's killed, but also on other circumstances involving, that person. And we see this reflected throughout the criminal law system, throughout the tort law system even. So yes, I think that that's a good idea. Secondly, I think that we can distinguish between terrible abuses of pro-life or anti-abortion movement and the core commitment of it. So I do not think a court-ordered C-section is permissible, because it's a wrong, it's a battery for a good end. And if you're a non-consequentialist in some contexts, you have to be a non-consequentialist in other contexts. Thirdly, the fundamental thing that I think that the pro-life movement is trying to do is, and we have to be held responsible to this as well. There was a question about this yesterday, is affirm the dignity of the most vulnerable, the most marginalized, the most at the ends of the community. Not just the young, the little, and the cute. So that has to be something I think we need to push ourselves toward if you're part of the pro-life movement.
Dorothy, you get the last brief word, right?
I'm just going to answer the questions that were directed to me. One, I didn't make any statement at all about whether abortions would increase if because abortion is legal. I said that more women would die from illegal abortions if it's criminalized. That was my point. And in terms of the adoptions, I don't think the fact that white people are given the choice to adopt black children and sometimes choose to do so says anything about whether the system is racist or not. What is racist about the system is that it devalues the family bonds and reproductive decisions of color. And it's the fact that so many poor black children are available for adoption is what is racist. It's the conditions that and policies that led to that, terminating their parents' rights, thereby making them available for whites to choose to adopt them if they want to, that is racist.
All right, well, please join me in thanking the panelists.